Welcome to Employment Law This Week. I'm George Whipple. On November 4th, the Centers for Medicare and Medicaid Services, or CMS, released an interim final COVID-19 vaccine rule for covered employers. While the rule might not have received as many headlines as OSHA's ETS for large employers, it applies to many healthcare providers, and compliance deadlines are imminent. Epstein Becker Green's Frank Morris is here with more.
The interim final rule is an important requirement now placed on those who participate in either the Medicare or Medicaid programs. It's an amendment to the conditions of participation in the program that will require that those employers who participate see to it that employees and others, even volunteers, for example, who come into the healthcare setting where there's a provision of services to Medicare and Medicaid recipients, that those individuals be fully vaxxed with an interim requirement of December 5th for an initial shot of a 2-dose round of vaccination, and ultimately by January 4th that they be fully vaccinated. Covered employers need to get into action because of the short dates for compliance with the program. What they should be doing now is getting policies and procedures in place so that they will be able to be compliant, one. Number two, they should be engaging in either initial or further educational efforts so as to help employees understand why the vaccination requirement is in place and what the advantages of being vaccinated are. Overall, I would make this suggestion, and what we've been talking with clients about is having a compliance officer. And that person might be called the COVID vaccine compliance officer, who is the ultimate point of contact for everything that an employer needs to do to assure compliance with the requirements of the mandate from CMS. And so that person is the person who will see to it that policies are in place, that educational efforts are made so that employers can bring in experts, whether they be their on-staff experts or others, to educate employees that they have proper paperwork and protocols for processing the exemption requests, that every checkpoint stops with a particular individual, hopefully designated throughout the organization by the CEO or the chief operating officer, to show that this has the seriousness of purpose in the organization for full compliance. Time is running. There are very short deadlines, and so the time to be active on getting into a compliant posture, because that's what CMS wants. CMS is not looking to put in place penalties. What they are looking for is compliance, and so employers would be well advised to take the opportunity to move forward aggressively to produce a compliant posture and show every good faith effort. To the extent then that there are some minor failures, every good faith effort having been shown is likely to prevent any consequential problems with CMS enforcement.
Thanks, Frank, and thank you for watching. We'll see you next time.